a long series of AI hearings before several pieces of legislation will be marked up. So I encourage members on both sides of the aisle to make sure that this panel of witnesses are asked questions that may be germane to proposed legislation or legislation already offered. I now recognize myself for an opening statement. Literally a generation ago, or in technology, 10 generations ago, a sharp young man graduated from Cal State San Marcos in my congressional district. He joined a company that I then was CEO of, Directed Electronics, which had an inherent inventory problem. The inventory problem was that we had a few SKUs that sold well and we managed, and hundreds of SKUs that were constantly either out of or oversupply of. It wasn't anyone's fault. We had simply grown quickly, and there was a certain amount of inconsistency in what was being sold in a given month. So that bright young man took all of that inventory and the records and put it into SuperCalc, a precursor to Microsoft Excel. Within weeks, we had reduced our out of stock, increased our same-day delivery, trimmed inventory to a level that actually saved us over $1 million a year in inventory maintenance cost. That bright young man continued to work at the company for many years. He did not continue to use SuperCalc for long because technology quickly gave better and better tools. The man, the program, the machine, both are necessary to implement and make AI a reality. But it was the man who made the machine that made the man a success. Over the last century, the US has led the way in virtually every area of technology because of our pro-innovation bias. We are the innovators. Well, China are the duplicators, and Europe, yes, are the regulators. As we speak, though, my home state of California, with an economy larger than that of Italy, is rivaling the European Union when it comes to trying to lead on regulation. This wouldn't be such an ironic occurrence, except we are the home of innovation and, yes, the new bastion of regulation. But just as in the 1990s, when America led the internet revolution, a light touch, such as that offered by the president in his initiative, in fact, must be the direction we go. Anything else will give us a problem that I will describe. If we, in fact, are not innovating 10 times faster than we're regulating, if the speed of innovation in the US is not at least months or, if possible, years ahead of China, their speed of duplication, some of it actually using AI to duplicate what we're doing, will in fact cause us to lose our edge. My home state is part of the problem. The European Union is part of the problem. But as you'll see from our witnesses today, all 50 states have implemented some form of AI regulation. And in fact, there are in the neighborhood of 1,000 pieces of legislation spread over 50 states that will create, if allowed to continue, a patchwork of indecision by the AI industry. Given conflicting regulations, given the inability to roll out with certainty technology, that technology simply will not be a priority. Let there be no doubt, though, either we win in innovation and we win in AI, or we lose our edge on the international stage. Vice President Vance said it best: America's AI technology must remain the gold standard worldwide. We must continue to produce the next generation AI, and we cannot do it with a patchwork of conflicting state laws. As of now, we are ahead. Let there be no doubt, we are ahead in hardware, we are ahead in software development. We are also on the leading edge of having the solutions for the energy problems. That includes modular nuclear reactors. It includes a willingness to provide innovative solutions. During the last break, I went to one of Apple's facilities, almost 1,700 acres located near Sparks, Nevada. What I saw there were some of the most impressive, simple buildings filled with endless rows of various levels of chips for both AI and conventional data storage. What I also saw was a system that used zero conventional air conditioning to maintain that cooling. They had managed to beat one of the major causes of unrelated energy consumption, which was air conditioning. Through an innovative system of evaporative coolers from locally available water and a filtration system that allowed those to operate 24/7 without in any way being damaged by the high flow of air, they are making advances. This is over and above the innovation that we're seeing in chips and the ones that we plan to, and the additional power. I'm going to contrast just over the border from California, this location in Sparks, Nevada, because it has 64 gigawatts of generation power. Why would they need it? Well, they'd only need it in case of a power failure. Not so. The first time all were operational was to prevent blackout in California, because California lacked the power, and by their going offline, Nevada was able to export power into my home state. That tells you a lot of the innovation in California, but not the ability to have those great new centers located there. In fact, Virginia, just a mile from here, is the #1 location, and other states are competing aggressively for it, and if nothing changes, they will win. These new laws will also affect early stage development, because technical experts, let alone lawmakers, are not capable today of predicting where we will be tomorrow. Earlier this year, in fact, overnight, the thinking on AI development and power needed took a sharp change, and everyone on both sides of the Atlantic and Pacific are learning from what was released, and that will continue. Of course, I don't want to be just a naysayer, because in fact, I am from an innovative state. I am from a state that is second to none in finding the best and the brightest and bringing them here. And although this committee does not have this subcommittee does not have jurisdiction over immigration, I want to make it clear here that AI development will also be about this committee working in a bipartisan basis to find ways to not just attract, but to retain the best and the brightest for that development. Let there be no doubt, there are 300,000 Chinese students studying in America, and most of them are being told to come home and bring with them what they're learning here. The release of the new AI action plan signaled to the world that the Trump administration needs Congress to legislate America First AI. Now, I know that sounds pejorative, but it isn't. The fact is that whether it was catching up on the, if you will, the interstate superhighway under Al Gore Sr., or it was leading on taking the ARPANET and turning it into the internet, we have worked together in the past. We have worked to limit states and to restrain our own overregulation for the benefit of our economy, and it has worked. I want to welcome the President's leadership and look forward to working to promote it. I want to additionally say that we have partners on both sides of the aisle. This committee, including, she's not here right now, but Zoe Lofgren and others, have been great partners in this in the past, and I expect they will be. Again, I just want to leave us with one truism. America has innovated and out-innovated the countries around the world for generations. Europe has become a regulator and admirer of our technology without embracing the way you get it. And China has become the most efficient stealer of technology. And the term duplication, if it was truly innovation, would be a compliment, but it isn't. With that, I recognize the ranking member for his opening statement.
Thank you, Chairman Issa, and thank you to the witnesses for your testimony today. When I drive from Georgia to Washington, D.C., about once every 6 months or so, and I get a chance to listen to the radio and scan and listen to all my favorite stations and tunes, I've got to pass through 3 states. I go through Virginia, go through South Carolina, go through North Carolina, and then I hit Georgia. And we all have had experience in crossing state lines before. And you'll have different speed limits and different levels of enforcement. You have the experience of figuring out what are the rules. So in other words, because you're going 79 miles an hour at the state line, and then flip to another state, and boom, all of a sudden the speed limit is 65. So you've got to then do 74 to stop from getting pulled over, and hope that that officers won't stop you. But anyway, when some suggested earlier that we in Congress should preempt all state AI laws, they would not just have done away with states' nascent generative AI consumer protections, they would have preempted common law causes of action against AI companies as well. When the doctrine of caveat emptor, or buyer beware, ruled American jurisprudence, consumers had minimal protection and were expected to thoroughly inspect products themselves. Judicial interpretations began to change in the middle 20th century as products became less straightforward and more complicated. Common law developed to better protect consumers in products liability and negligence cases. Today, most Americans can hardly imagine taking apart a toaster, let alone an AI chat box, to make sure that it works correctly. But caveat emptor is effectively what advocates of a moratorium are suggesting we revert to when we talk about an AI moratorium. When you preempt an entire field of law, you're preempting the common law right along with it. Supreme Court law has repeatedly found, as it did in Regal versus Medtronic, that a federal law's reference to a state's requirements includes its common law duties. And in plain language, that means if Congress preempts state AI laws, we also preempt state common law, unless the legislation explicitly says something else. Common law cases to protect consumers are already being filed against generative AI platforms. 2 days ago, Senator Hawley held a hearing on the harms to children using AI technology, calling witnesses whose children died or were hospitalized after interacting with artificial intelligence chatbots. I know some of the parents and families are in the room today. Kristen Bride, Juliana Arnold, Mandy Furness, and Megan Garcia. I'm so sorry for what you all have been through, and I admire your commitment to justice. Common law is crucial to the protection of Americans because it exists no matter whether there are comprehensive state laws on the books or no laws governing new technology on the books. Even when there are no statutes, common law helps us set a floor for a standard of care as a society. When some of my colleagues across the aisle talk about a moratorium, preempting common law is exactly what they're talking about. Carve-outs might be offered for some areas of the law. Others may get a loose regulatory structure. But what many don't realize is that the glue that holds the law together would be wiped out in almost every scenario. By protecting common law, we can protect that floor that ensures every person harmed can seek to have their case heard before a court of law. This basic standard of care can spur innovation by preventing a race to the bottom, and it can offer a level of security as the federal government and states determine what the best next steps are for AI in the United States. And with that, Mr. Chairman, I yield back.
I thank the gentleman. Does the gentleman from California seek to be waived onto the committee? Without objection, the gentleman be waived on, even though he's not a member of the subcommittee. And if others yield time to him, he'll be permitted to ask questions. Without objection, so ordered. It is now my pleasure, notwithstanding the chairman and ranking members arriving, to introduce our distinguished panel of witnesses. Dr. David Bray is a distinguished fellow and chair of the Accelerator at the Alfred Lee Loomis Innovative Council at the Simpson Center. He previously served as IT chief at Bioterrorism Preparation and Response Program at the CDC and in the intelligence community. Dr. Bray is the recipient of a Joint Civilian Civil Commendation Award and National Intelligence Exceptional Achievement Medal. Welcome. Mr. Kevin Fraser is the AI Innovation and Law Fellow at the University of Texas Law School. His research focus is on how to design regulatory regimes that increase adoption and use of AI. Mr. Fraser also leads the AI Innovation and Law Program, which prepares students for careers related to artificial intelligence. Thank you for being here. Mr. Adam Thayer is the Senior Fellow for Technology and Innovation at the R Street Institute, a free market think tank. His work focuses on cultivating emerging technologies. He previously was Senior Fellow at the Mercatus Center and was President of the Progress and Freedom Foundation. Professor Neil Richards is the Koch Distinguished Professor at Washington University School of Law, where he also co-directs the Cordell Institute for Policy in Medicine and Law. His work focuses on privacy law and information law and freedom of expression. We welcome all of our witnesses here, and as you may have seen on C-SPAN, it is the rule of the committee that all witnesses be sworn in. Would you please rise to take the oath? And raise your right hand. Do you solemnly swear or affirm on a penalty of perjury that the testimony you're about to give will be true and correct to the best of your knowledge, information, and belief? So help you God. Please be seated. Let the record reflect that all witnesses answered in the affirmative. As you also have heard many times, your true entire statement, including reasonable, even if expansive, additional information you submit, will be placed in the record. So as a result, if you're going to go past 5 minutes, do so by extension and summarize what you do so we can leave time for questions. And with that, we will begin. Right, they've got me, I want to make sure I get the right end, Dr. Bray. After this, it gets easy. We just go across.
Thank you, Chairman Issa, Ranking Member Johnson, and members of the committee. I appreciate the opportunity to testify today. I'm Dr. David Bray, Chair of the Loomis Accelerator at the Stimson Center, Principal at Lead to Adapt Ventures, Senior Advisor at General Catalyst Institute, and a Fellow with the National Academy of Public Administration. I work on tech, data, and geopolitical issues to help startups scale, communities adapt, and legacy organizations transform themselves amidst rapid global changes. My testimony focuses on advancing reliable, trustworthy AI consistent with the values of free societies and free markets from these perspectives. I place my remarks in the context that the United States is experiencing multiple tech revolutions in addition to AI, advances in space technology, biotech, quantum tech, and the miniaturization of sensors and robots, all impacting US companies, our workforce, and our communities. With respect to AI, I would like to mention 3 noteworthy advances to inform our discussion. First, active inference AI models themselves demonstrate faster learning and use less data and less energy. Such approaches can be bounded by spatial or temporal limitations in ways that are human-readable and interpretable across AI systems. Each of us as individuals could, in the future, restrict what AI systems do on our behalf. Second, open-weight AI models with open-source code have shown we can transform currently complicated processes, such as a Veterans Affairs form, into a conversational interface, dramatically reducing the time to complete and speeding access to care. Third, federated learning allows AI systems to learn on data sets where they exist with proper consent, empowering both individuals and organizations to choose if their data sets and intellectual property are usable by an AI, and negotiate a beneficial contractual relationship in return. Given these advances, 3 guiding principles drive my recommendations to the subcommittee. First principle, US strategies for advancing AI should recognize interdependencies between AI and other tech advancements. This requires a light touch policy framework. Recently, the National Academy of Public Administration has illuminated methods for sufficiently agile policy approaches to achieve measurable goals at the pace necessary given global changes. Second principle, different AI methods carry different risks and benefits. For example, AI approaches to computer vision and expert systems follow predictable outcomes, whereas generative AI produces less predictable results. As such, AI policy should reflect these differences in AI methods. Third principle, there have been multiple waves of AI improvements over the years. We should expect continued advancements, which means US policy approaches must adapt accordingly. For example, the Stimson Center's Loomis Council intentionally brings together industry leaders to adapt projects to new AI developments. Even with different AI methods and the need for continuous adaptation, groups tied to specific domain applications of AI, for example, healthcare, transportation, and finance, can promote data-level interoperability across AI systems, avoiding silos. When electronic health record systems advanced in the 2000s, the United States encouraged the nonprofit Health Level 7 to evolve an open standard framework for interoperable clinical data with privacy controls. We should do something similar now for health and AI. We each deserve a choice as to when AI uses our data, and medical doctors should not be hindered by non-interoperable AI systems. Given these principles, my recommendations are as follows. First recommendation, our principles and policies should help advance freedom, human agency, and individual liberties. We face global competition from the Chinese Communist Party regarding AI's future, including their AI Plus initiative. US AI strategy must simultaneously encourage the advancements of the entire US AI industry and encourage the industry to advance individual freedoms. Second recommendation, upgrading existing domain-specific laws is more pragmatic than adapting new sweeping AI regulations. I recommend a domain-specific approach because the risk of different AI methods vary by applications. Examples include updating the Privacy Act of 1974, revisiting HIPAA, and reviewing other existing laws where the speed, scale, and scope of AI methods impact different risk calculus. Congress's recent efforts to upgrade banking laws with respect to stablecoins is another example of updating existing statutes given new technologies. Third recommendation, assess what actions consistent with the US values of freedom, human agency, and individual liberties may need light touch policy to ensure AI advances freedoms across our nation. When updating policies that already exist, we should build on Justice Brandeis's concept of a right to be left alone as law-abiding citizens, including choices about when personal data sets are and are not used by an AI, as well as when AI and any associated intellectual property shared is processed locally as opposed to a cloud-based instance. Any national AI strategy should ensure we do not stifle advancements towards reliable, trustworthy AI consistent with the values of both free societies and free markets. Thank you, and I look forward to your questions.
Thank you. Mr. Fraser.
Chairman Issa, Ranking Member Johnson, and distinguished members of the committee, thank you for the opportunity to testify. My name is Kevin Fraser. I'm the AI Innovation and Law Fellow at the University of Texas School of Law. Outside of teaching students, I believe there is no greater purpose for academics than sharing knowledge with policymakers. This purpose is all the more paramount when it comes to complex and novel challenges like harnessing AI to unleash human flourishing. A few months ago, Dr. Jensen came before this committee and announced that the nation that leads in AI will shape the future. Nothing has changed in the interim. What remains uncertain, however, is whether the US will retain its leading position. My goal today is to address the proper role of the states and the federal government in shaping AI policy. On governing the use of AI, the 10th Amendment reserves extensive authority to the states to regulate within their borders. On the matter of AI development, the founders offered their answer in abandoning the Articles of Confederation and adopting a strong, centralized government capable of protecting and advancing the national interest. As I'll explain in the rest of my testimony, the founders infused 3 principles into our Constitution that, when applied to the AI discussion, resolve debates about the authority of each actor to shape AI development. Subsequent changes in related areas of the law, namely the Commerce Clause, have given rise to the false impression that muddled judicial interpretation somehow relaxed these principles. However, they remain as foundational today as they were 200 years ago. Adherence to these principles is essential both as a matter of fidelity to the founders' vision, as well as to securing an AI regulatory posture that aligns with our federal system. The first principle is that the federal government alone is responsible for matters that implicate the economic and political stability of our country. The emerging threats to national security and economic stability posed by advances in AI place regulation of training frontier AI models squarely in the authority of the national government. To focus on one of many examples, AI has lowered the barriers to the creation and deployment of bioweapons by bad actors. Defensive measures have not progressed at the same rate. Experts warn that with significant technical progress, the nation would still need to adopt extreme measures to ready ourselves for a near future in which synthetic pathogens go undetected. That effort will flounder with second-rate AI. Training frontier AI models, and by extension, safeguarding our national health and prosperity, cannot be waylaid by state laws, no matter how well-intentioned. Second, the extensive authorities reserved to each state end at their respective borders. As the Supreme Court has specified on multiple occasions, the equal sovereignty of the states is a fundamental principle of our Constitution. Our constitutional order does not condone one state to intentionally and substantially interfere with the liberty and freedom of another. Political clout, economic might, nor population grants one state the authority to project its legislation into another. Whether a state is the 4th largest economy in the world or the 104th largest has no bearing on its authority to shape the lives of Americans beyond its borders. Though the Supreme Court has tolerated the inevitability of some regulatory spillover, its recent holding in National Pork Producers Council v. Ross does not permit the sorts of regulations pending before many state legislatures. Regulations that may deny all Americans access to a good itself because of the preferences of one political community. Building new pig pens to satisfy the preferences of Californians is technically and financially feasible. Training 2 AI frontier models, one to comply with the preferences of a single state and one for the rest of us, is a billion-dollar undertaking that rests on uncertain and evolving realities. Contradictory and vague state laws that impact AI development may thwart the sort of technological progress that has long fueled the American dream. Under a patchwork of state laws that impact AI development, we will see that Americans may never experience the improvements in education and healthcare that could have been realized by a national approach to pursuing the AI frontier. The third principle is that the ultimate authority in our constitutional system rests with the people. Our founders aspired for every American to exercise meaningful control over their daily lives. Extraterritorial regulation of AI jeopardizes these and other features of individual agency. The nature of AI development means that if labs are compelled to comply with one state's regulations for model training, those requirements will be imposed on the rest of the country, rendering us all less likely to realize the benefits of AI advances. Americans may be able to move as freely as they'd like, but they would still find themselves using AI tailored by state legislators over which they have no control. Such a world is the antithesis of liberty. Denial or delay of the most sophisticated AI as a result of flawed state legislation is not a matter of mere inconvenience. It's a question of access to the greatest driver of human flourishing we've yet to develop. Thank you again for inviting me here today. I look forward to your questions.
Thank you, Mr. Thier.
Chairman Issa, Ranking Member Johnson, and members of the subcommittee. Thank you for the invitation to participate in this hearing. My name is Adam Thier, and I'm a senior fellow at the R Street Institute, where I cover emerging technology policy. My message here today boils down to one simple point. Congress needs to act promptly to formulate a clear national policy framework for artificial intelligence to ensure our nation is prepared to win the computational revolution. If we get this wrong, the consequences could be profound in terms of geopolitical competitiveness, national security, economic growth, small business innovation, and human flourishing. Unfortunately, America's AI innovators are currently facing the prospect of many state governments importing European-style technocratic regulatory policies across America. As you noted, Mr. Chairman, more than 1,000 AI-related bills are already pending across the nation. But some states are far more aggressive and influential on national market outcomes than others. Almost 50 AI-related laws are currently pending in California, and New York is currently considering almost triple that number. Sacramento and Albany should not be dictating AI policy for the entire nation. That approach is especially problematic for so-called little tech innovators who will struggle with confusing, costly compliance burdens. America would not have become the global leader in digital technology it has if we had had 50 state computer bureaus or even a single California Computer Commission allowing to license every single aspect of interstate computing and treat the internet as a regulated utility. Thankfully, America avoided that fate because of wise bipartisan decisions that this Congress made in the 1990s, which let digital technology be born free as opposed to being born into a regulatory cage. Laws like the Telecommunications Act of 1996 and the Internet Tax Freedom Act of 1998 included important provisions, preempting and facilitating a national digital marketplace. The U.S. is now the global leader in almost every segment of computing and digital commerce, thanks to this wise policy approach. Now is the time for Congress to work the same magic for AI by creating a national framework to prevent a patchwork of state mandates from undermining AI innovation. Colorado Governor Jared Polis has called upon Congress to preempt state AI laws, such as the one his own state passed last year, and he has even endorsed the idea of a state AI regulatory moratorium like the one Congress considered this summer. Other governors have raised similar concerns. Connecticut Governor Ned Lamont has warned of, quote, every state going out and doing their own thing, a patchwork quilt of regulations, he said. And just last week, New York Governor Kathy Hochul noted how, quote, it's hard when one state has a set of rules, another state does, and another state. I don't think that's a model for inspiring innovation, end quote. Congress could again try to implement a moratorium, or it could formally preempt specific state and local regulatory enactments that impose an undue burden on interstate algorithmic commerce. If Congress chooses the latter option, federal lawmakers should first preempt state regulations of AI frontier models because the costs associated with such regulations would outweigh any local benefits. Such rules would create spillovers and undermine development of the system the nation needs to compete globally. State officials also lack the technical expertise and information about national security matters that could be relevant to AI safety considerations. Second, for issues related to so-called algorithmic bias or AI discrimination, Congress should preempt state efforts to regulate the development of AI systems and applications through cumbersome and confusing mechanisms such as AI audits or algorithmic impact assessments. To the extent any such ex-ante regulations are imposed, it should be done at the federal level, and existing federal civil rights laws and non-discrimination standards should apply. Finally, Congress should also require the National Institute of Standards and Technology and the new Center for AI Standards and Innovation within NIST to oversee a new standing AI working group to coordinate and work to resolve other federal state AI policy matters. NIST and CASI could help devise more workable, consistent standards for AI policy matters not already preempted by federal law. Even where the scoping of federal preemption proves difficult, everyone should agree that AI development will be discouraged if America has dozens of different definitions of key concepts. Inconsistent standards will undermine market certainty and hurt investment, innovation, and competition. Ongoing congressional oversight of this process will be essential, and Congress can simultaneously consider what sort of new light touch rules might be necessary at the federal level to address various AI safety concerns. Meanwhile, state governments still have a role to play and will have plenty of room to act using a diverse policy toolkit of generally applicable laws to address any real-world harms that might come about from AI applications. In closing, the time has come for Congress to exercise its constitutional responsibility to protect the interstate marketplace and the national interest in the development of robust AI capabilities that will ensure the United States remains at the forefront of this technological revolution. Thank you for holding this hearing, and I look forward to any questions you may have.
Thank you, and particularly thank you for mentioning our former colleague, Mr. Polis. Professor Richards.
Chairman Issa, Ranking Member Johnson, and distinguished members of the committee, thank you for the opportunity.
Could you either put it closer or turn it on or both?
Sorry, Mr. Chairman.
Fantastic, not a problem at all. We're talking tech here, so let's go. We'll go high tech and turn them on.
We have the automatic ones in St. Louis, so.
Of course you do.
Chairman Issa, Ranking Member Johnson, and distinguished members of the committee, thank you for the opportunity to appear before you this morning. My name is Neil Richards, and I am the Koch Distinguished Professor in Law at Washington University in St. Louis, where I direct the Cordell Institute. This hearing is about whether Congress should consider preempting state laws that touch on artificial intelligence technologies. And it is my firm and considered opinion that denying states the ability to regulate novel technology issues going forward would be a grievous and avoidable error that would not be in the best interests of American industry or the American people. I'd like to offer three high-level points this morning. First, federal preemption of state laws touching AI would be reckless and expose consumers to great risk of harm. Artificial intelligence, as we've already heard this morning, is not just one technology. It is a cluster of related and changing technologies that would be nearly impossible for a general preemption law to define with care. In addition, AI technologies will likely affect every aspect of human life, just as industrialization did starting in the 19th century, and as the internet did starting in the 20th. Like those before them, AI technologies will produce many good things, but also many bad ones, like kids becoming emotionally dependent upon chatbots, generative AI hallucinations affecting our courts by making up false citations, new ways to hack systems, and other harms critically that we cannot foresee today. At a time when we cannot be sure what harms will result, at a time when we can be sure that harms will result, but we cannot be sure how, depriving states of the ability to adapt to and try to mitigate these harms would be to disregard a clear and obvious risk, and that is the legal definition of recklessness. Second, states have been pioneers of sensible tech regulation over the past 3 decades that has built essential digital trust for tech companies. If states had been banned from regulating the internet in 2000, we would have no broad requirement for website privacy policies, no data breach notification laws, no laws banning employees from demanding the social media passwords of their employees, no laws regulating facial recognition technology, no substantive data security statutes, no comprehensive privacy statutes, no laws preventing kids from accessing hardcore digital pornography or other dangerous content, no laws limiting the ability of tech companies to peddle addictive business models to children, and much less enforcement of digital fraud, abuse, crime, hacking, and data breaches. Guided by these state legal guardrails in place to secure essential consumer trust, the past 30 years have seen the explosive success of Silicon Valley. Without state privacy and security laws, for example, we would still be afraid to give our credit card numbers to Amazon. State digital laws have tamed the worst excesses of the internet and helps to make it a trustworthy place for innovation, connection, free expression, and business. And broad AI preemption would have the opposite effect for artificial intelligence. Third, I would like to address the claim frequently made by industry that state regulations somehow stifle innovation. As history makes clear, these arguments are, in my opinion, mistaken and misguided. Law creates and enables innovation by stabilizing the marketplace. It sets the ground rules for fair and robust competition, making the market safe and sustainable for consumers. Contrary to its libertarian origin myth, Silicon Valley was shaped by laws from the beginning, from government defense contracts to intellectual property laws, and from securities laws to federal and state prohibitions on unfair and deceptive trade practices. Law has always played a role in preventing scammers and thieves, and in shaping corporate business practices so that they benefit society as a whole. It is the presence of regulation, including state regulation, that has led to America being a leader in digital technologies and services. While we can certainly, and I'm sure we will this morning, debate how much regulation and what kind is appropriate, having no new regulations at a time of rapid change would be a disaster. And if innovation is as magical as industry says it is, it can still do good things while respecting the policy choice of the people's elected representatives. In this way, the necessity required by reasonable regulation has been and should continue to be the mother of invention. In conclusion, stripping our states of any power to regulate AI, potentially anything done with a computer, would be a reckless and grievous error. State regulations have always played an essential role in building consumer trust and shaping the digital revolution for the better. Thank you and I welcome your questions.
Thank you. I understand the ranking member would like to make an opening statement.
If that's all right with you, Mr. Chairman.
It is always good to hear from you.
Well, thank you kindly.
Gentleman's recognized.
I'm very grateful to you for putting together this really important hearing, and thanks to the witnesses for your statements. When commercially available AI debuted 3 years ago, the consequences were breathtaking from the start. Generative AI spurred scientific research and provided astonishing new tools to creators. The massive jumpstart to American innovation swept from social and economic domain to social and economic domain, from pharmaceutical research and quantum computing to sound recording and film editing. But generative AI has also raised profound legal, practical, even philosophical problems, such as whether individuals have a right to their name, their image, their likeness, and their voice when they're used in other people's deep fakes. If government has unlimited power to engage in AI-enabled surveillance of our citizens, and what are the appropriate standards of care, if any, for AI platforms to protect users against harmful consequences? Well, Congress takes the time to absorb the shock of these changes and these problems and examines the technology. The states have already begun to enact the first regulations on AI. We often talk about creation of rules for the road when crafting legislation to govern new technology. But I think this way of talking about consumer safety and technological ethics suggests that a road without speed limits would get us to where we're going faster. For generative AI, it's not about creating speed and safety laws and building highway guardrails, but rather building a road system in the first place. Some of my colleagues would argue that the construction of local roads is unnecessary. They say that without broad preemption, without clearing the field of all state-based legal encumbrances, AI companies and fledgling startups will have trouble complying with state laws and will be put to a disadvantage and then wither on the vine. I've heard little to suggest that broad preemption is in fact the appropriate solution to this problem. Proponents of preemption present Americans with a series of false choices, telling us we must choose a side between AI innovation or state powers and federalism, between business and consumers or national security and safe innovation. In 1816, Jefferson wrote, "Laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, as new discoveries are made, new truths discovered, and manners and opinions change, with the change of circumstances, institutions must advance also to keep pace with the times." What we're seeing across America is individual states looking at these amazing technological developments and asking whether and how their laws need to change to protect their citizens and advance the common good. Today, you might think that the issue has some kind of necessary partisan valence to it, Republicans on one side, Democrats on the other, but opposition to an AI moratorium, I think, is broad and bipartisan. In fact, when some of my Republican colleagues tried to pass a moratorium through our last spending bill, attorneys general from across the states, red, white, and blue, sent a letter to Congress saying, please don't do this to our state laws. In another letter, 17 Republican governors wrote to Majority Leader Thune and Speaker Johnson, praising their, quote, big, beautiful bill, but explaining that the moratorium provision, stripping the right of any state to regulate this technology in any way without a thoughtful public debate, was, quote, the antithesis of what our founders envisioned. I surely disagree with these governors on many things, but I think that they are right and should indeed be free to create what they call, quote, smart regulations of the AI industry that simultaneously protect consumers while also encouraging this ever-developing and critical sector. In a statement submitted for this hearing, AI startup Bria wrote that a moratorium on state laws would create a giant vacuum and strip away the rules needed to, quote, raise capital, foreign partnerships, and build safely in order to win consumer trust. Without a road on which to travel forward, startups are cut out of the market in favor of large companies with the legal and fundraising teams necessary to deal with a barren legal landscape. Finally, some argue we need unrestrained AI development to properly compete with China. The subcommittee has held many bipartisan hearings on the threat to innovation, AI supremacy, and IP from China. it would be amazing, I think, even dangerous to posit that we need to become more like China to compete with China. In fact, it seems more plausible to me that to believe that stronger, better products developed in America while protecting Americans and their data through American political processes and the passage of American laws will ensure that AI is both more advanced, more durable, and more internationally competitive. Protecting American innovation, investing in American research, developing American laws to deal with problems like deep fakes, political deep fakes, discrimination through AI and so on, and investing in our workforce, I believe, is the right way to win the so-called AI arms race. American safety is not at odds with AI innovation. That should be the baseline for any conversation we have about the best way moving forward. And I very much look forward to this conversation and have already learned a lot from it. Yield back to you, Mr. Chairman.
I thank the gentleman. All other opening statements, without objection, all of their opening statements be placed in the record. It is now my pleasure to go to the gentleman from Virginia, Mr. Klein, for 5 minutes.
Thank you, Mr. Chairman. I want to thank the ranking member for referencing our third president, gentleman from Virginia, Mr. Jefferson, and one of our great inventors from our earliest days of our republic, and for the chairman referencing the work of our current governor, Governor Youngkin, who is working to make sure that Virginia is the leader in data center development. We continue to be the leader nationally, and we intend to stay that way as AI grows and develops. Mr. Frazier, you've written that the Constitution's intellectual property clause is first and foremost a directive to advance and spread knowledge. I think that was on X a couple weeks ago. How should Congress strike the right balance between protecting copyright owners and ensuring that AI regulation continues to promote the spread of knowledge consistent with that constitutional purpose?
Thank you very much for the question, Congressman, and thanks for the follow, or at least perhaps the like. I think in this regard, the Constitution is clear that the IP clause has always been grounded in progressing the promotion of science and useful arts. And here, if you go back to the founding articles, as well as subsequent interpretation by the Supreme Court, the focus has always been on making sure that there's the spread of knowledge across the country. IP laws grant an exclusive right to creators to attempt to incentivize that creation. What we need is to make sure that there is an economic analysis of the extent to which those laws are working as intended. The purpose of the IP clause is not the profit of creators, it is the progress of society. And so what we need to get back to are those first principles when it comes to examining copyright law and patent law. Right now, if you look at analysis from scholars such as Richard Watt, you will see that the preponderance of copyright benefits are not going to your average Joe and Jane author, but to large publishers. And so we need more analysis on that front.
Would you agree that ensuring transparency in AI systems, such as being able to trace what data was used to train a model, is essential both for protecting IP rights and for maintaining public trust in AI platforms?
I would agree that broad overviews of the sources of training data are important to get an understanding of where and how models are being trained.
And in that same spirit, could giving creators a private right of action for tampering with content credentials help strike the right balance between protection and innovation?
My own estimation is that granting that sort of right would be a significant barrier to AI innovation, given the centrality of access to data for innovation. We've seen that many courts and many scholars have regarded the use of data as a transformative purpose under copyright law, and denying the ability to train on wide swaths of data would be a real hindrance to our ability to leverage AI. As many folks have said on many occasions, bad data leads to bad AI. If you want better AI, you want better quality information. And if we throw many legal gears into that equation, we won't get the AI we deserve.
Thank you. Dr. Bray, as we consider whether and how best to regulate AI platforms, do you believe that we must avoid the same mistakes we made in the early days of the internet with broad safe harbors that gave platforms a free pass for enabling copyright infringement and countless other harms?
Thank you for that question, Representative Klein, and as a fellow Virginian, glad to be here. So I was around actually working in the 90s on the early days of the World Wide Web, and my observations would be we did fit for purpose for the 90s. Now, in the 2 decades since, we have seen the rise of applications on top of that technology where we may need to make adjustments. And I think what we need to separate is the desire to roll out the technology so that the entire nation could have access to the internet. And at the same time, if we see that the applications need adjustment to the law, that would make more sense to adjust. However, I would say what we need to recognize as well as we go forward here, where are we trying to advance the technology so it can be used by startups, it can be used by communities, it can be used by legacy organizations that haven't gone AI native yet. And at the same time, if we see there are applications where we want to prevent harm to individuals, to children, or things like that, adjust the applications while not limiting innovation on the technology.
Just like other businesses, bad actors have to be accountable for the harms they cause. And in addition, if we consider some type of temporary pause for state-level AI-specific regulation, we have to ensure that other generally applicable state and federal laws continue to apply, with copyright law being one example. Do you think AI platforms should be held to the same standard of accountability as any other business, including when it comes to respecting copyright?
Absolutely, and I would actually say that's why I'm so excited about federated learning, because there actually could be the opportunity where, whether you're a recording artist, you're a musician, you're an individual, you could actually say, here's the data that I have pooled. You can learn on my data in situ as opposed to shipping it somewhere, and we can have that actually recorded as a transaction. And then in return, I'm getting benefit, whether it be financial or otherwise. It's a new model that's actually quite possible. It's been possible for more than 5 or 6 years, and we can motivate people to do it.
Great. Thank you. I yield back.
Gentleman yields back. Who seeks recognition? The gentleman from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. Professor Richards, I mentioned in my opening statement my concern that broad federal preemption of state AI laws would also preempt common law causes of action. How does common law, particularly tort law, help protect Americans from harm?
Well, thank you for the question, Representative Johnson. Common law is the foundation of American law. It is older than the United States. It goes back to the colonies, to the English tradition. Common law has a flexibility to the law. If we think about my own specialty, privacy law, there was a reference earlier by one of the other witnesses to Justice Brandeis's right to be let alone. Privacy law in America, it was originally a product of common law, where the law adjusted to realize that data about people, information was being collected without their willingness, it was being disclosed. And an important line of cases relevant to this subject today, to protect the names or likenesses of people who pictures and names were being used to sell products without their consent. So common law is a tremendous source of flexibility and vitality in our law that allows the law to adjust to change circumstances like the advent of technological revolutions such as artificial intelligence.
Thank you. Can common law be used to protect Americans even in the absence of explicit statutes?
Absolutely, sir. I mean, that is sort of the nature of the common law, that the judges can apply the existing rooted principles of tort law and contract law and property law, and they can, from those general principles, divine specific applications that can provide new protections so that the law continues, as it always has, to evolve alongside technological invention, as the ranking member referred to Mr. Jefferson's statement from 1816, which, as a proud graduate of UVA, I also endorse.
Some of the current lawsuits against AI companies are being brought under common law to hold companies accountable for the harm that their products have caused to children. For example, Megan Garcia is suing Character Technologies and Google after her 14-year-old son, Sewell Setzer, died by suicide. She testified before our colleagues in the Senate this week that his death was, quote, the result of prolonged abuse by AI chatbots, was the result of prolonged abuse by AI chatbots on a platform called Character AI, end quote. The chatbot sent Sewell sexual messages and asked him to come home to me as soon as possible. Others have filed lawsuits against Character Technologies and OpenAI for wrongful death, negligence, and other causes under both common law and state laws about deceptive or unfair trade practices. These tragic cases show some of the worst possible harms that can arise from AI technologies. Professor Richards, does an AI moratorium run the risk of impeding these lawsuits that seek to hold companies accountable?
It would, I particularly if it were defined broadly. And let me also say in response to your question, Representative Johnson, as a parent myself, my heart goes out to the families who've lost their children. I think when we think about laws like negligence or rules like negligence, negligence was the great innovation of the common law to respond to industrialization. It means that anybody acting against other people must behave in a reasonable way and not cause unreasonable harm. I am sure that the car companies and the railway companies and the industrial companies of the 19th and 20th centuries would have argued that the common law developing the law of negligence would have impeded innovation, but actually it safeguarded the development of those technologies by enabling us to be able to drive cars and ride on the rails and fly in airplanes and otherwise enjoy the benefits of our inventions, knowing that we are safe and we are protected. And where those technologies or their deployers overstep the line, we have a right of action to defend our rights and protect our families.
Thank you. And it was states that developed the common law. Professor Richards, beyond common law, are there some areas where it's appropriate for states to lead the way on laws about AI technologies? And if so, what sectors or use cases should continue to be the providence of the states?
I think the answer to that question is yes. And I think particularly where there is deployment of AI rather than generation of AI, the use of AI in point of sale devices, employment discrimination, consumer protection, the traditional provinces of state regulation. And let me also, if I could add one additional thing, Representative.
Briefly.
States have filled the gap that this Congress, which did not regulate the internet, did not regulate privacy generally, have done so. And I think with AI technologies, if Congress is for whatever reason not able to pass comprehensive legislation protecting Americans, states will continue to fill that gap as they have in the internet age.
Thank you. We now go to the gentleman from Texas, Mr. Gooden, for 5 minutes.
Thank you, Mr. Chairman. Mr. Frazier, as a trend, it seems like every state's jumping to regulate AI, and perhaps some of them are doing it just to show early participation. Do you think that's well thought out? And also, what are the long-term effects of having a decentralized patchwork of laws? How does this help or hinder new entrants?
Thank you very much for the question, Representative. Always good to talk to a fellow Texan. Hook 'em. So I think in any prior study we've seen of the impact of a rush to regulate among states, there is a real noticeable impact on small businesses. If we look to research, for example, from INGEN, done in conjunction with the Michigan Ford Public Policy School, we see that just changing a privacy policy statement may be $6,000 in funds to outside counsel. That's $6,000 out of $55,000 of monthly revenue and operational expenses. So from a small business perspective, the rush to regulate is a real hindrance on innovation. I also think that the rush to regulate among the states creates a patchwork and a huge risk of extraterritoriality in terms of application. We've talked a lot about Virginia today, which is welcome. At the time of the founding, Virginia had around 700,000 residents. Delaware and Rhode Island, something around 30,000. The founders didn't say there was a Virginia privilege or we should have a Virginia effect. They did not want to see that happen. Instead, they made sure that states stayed in their respective borders when it came to regulation.
Thank you. And is it possible, do you think, for bad actors to misuse inconsistencies, especially in terms of violating intellectual property rights?
I think that we've seen a documented effect of what's referred to as regulatory overload, as folks at the Mercatus Center have written about. When we have endless litigation, endless labels, endless warnings, actually what we get is less safety because people don't know what law to adhere to. If you talk to a lot of startups today, they don't have a public policy person. They don't have a general counsel. So just adding more laws to the equation actually reduces the odds of user safety.
Thank you. I appreciate that. I yield the balance of my time to Mr. Correa from California.
Thank you, Mr. Gooden. Gentlemen, listening to your debate today reminds me of what General Patton used to say, which is lead, follow, or get out of the way. AI is moving faster than we imagined or we even expected just last year. touching every aspect of our lives. Most of our constituents, like many of us here, don't know a lot about it, but they know enough to expect that we here will protect them, their jobs, their children, their intellectual property. And so the debate about whether it's local control or federal control, I think is second to the fact that we just can't move on this stuff at the federal level. And so, Mr. Frazier, you're from Texas, I'm from California, fourth largest economy in the world. But how do you coordinate federal and state action to make sure that we respond to our constituents responsibly? Thank you.
Thank you for the question. And I was a Berkeley law grad, so I share some California ties. I want to emphasize that we do need to see regulation in this space, and we need to see that Americans are protected, and especially our vulnerable communities and children. What I'm concerned about are laws like AB 1046 out of California, for example, that imposes on AI companions a desire to prioritize factual accuracy over a user's preferences.
1047 or 1046?
AB 1046.
Okay.
Prioritizing factual accuracies over the preferences of the user, in this case, a child. To which I ask, who gets to define factual accuracy? Is it California state government? Who's going to answer the question of, is Santa real for a 7-year-old? Who's going to make factual determinations about religion for that child user? Those questions shouldn't be answered by California for the rest of the country.
I would ask you to also look at SB 53 that's now being addressed in the California state legislature and see what you opine on that as well.
I think SB 53 is the least bad option I've seen with respect to AI development regulation. As we've discussed in this hearing, AI development, in my opinion, and in the opinion of many, should be left to the national government as a core.
Anything you agree with in SB 53?
I very much agree with the whistleblower protections. I think that's an important mark. I also agree with the fact that it calls on regulators to revisit definitions and terms frequently to make sure they're working as intended.
Thank you, Mr. Gooden. And Mr. Chairman, I yield.
Thank you. We now go to the ranking member of the full committee, the gentleman from Maryland.
Thank you very much, Mr. Chairman. I don't understand the attack on the patchwork of laws. I mean, first, maybe that's because I'm a quilt person and I like patchworks, but isn't that what federalism is? Federalism is a patchwork, and that's the glory of the American governmental system. To be sure, the Congress gets it together to adopt a national law eventually on everything from the Clean Air Act to the Clean Water Act to the National Labor Relations Act, the Fair Labor Standards Act. But I think it would have made no sense to say before those federal laws were passed, let's wipe out the state laws that exist on child labor or minimum wage or not polluting the water or not polluting the air. In fact, that contradicts what I thought the central dynamic of federalism was, which is the states are the laboratories of democracy, as I think that was Brandeis. And then the different changes that they make are compared to each other, and then they bubble up, and Congress takes all of it into account when it decides to attempt a nationwide approach. Is that a fair statement of the situation, Professor Richards?
Absolutely. I think I also have a degree in early American history from the University of Virginia. And my studies in early federal history.
Virginia's getting a lot of play today. I don't know. As a Marylander, I got some questions about that. Yeah.
Would you like me to continue?
Please.
Absolutely. The goal of federalism is to have laws that are more responsive to the people who are closer to those representatives, that the legislatures of particular states can adapt to that particular state's problems and strengths, and also to protect, to experiment.
Okay, so just to restate the obvious, there was an attempt to impose a moratorium on state laws or to wipe out state laws. How is that different from the way that federal preemption has taken place in the other cases that came to mind for me?
Well, sometimes federal preemption can just through the supremacy clause preempt particular laws or laws that are inconsistent with a federal mandate. In addition, Congress is allowed to operate in ways to set a general national standard, but still allow states to experiment with stronger standards so that the innovation in regulation can continue apace with the innovation in technology, as you and Mr. Jefferson put it so well.
Well, and in addition to those differences, isn't it the case that a moratorium today would just wipe out state laws without substituting anything, without imposing a national law? I mean,
Absolutely.
Is there any precedent for just doing that, saying we don't want any state laws at all while we think it over or while we're stuck in some kind of legislative paralysis?
I can't think of one, and that's why I think it would be disastrous, because depending first on how the law is defined, it could sweep very, very broadly and take out laws that are important and protective, that everybody on this panel would agree are good laws. And second, if you have broad preemption, this would be a defense that tech companies could make in every piece of litigation, increasing the cost in the litigation system as the contours of that preemption definition could continue to affect litigation years into the future.
Yeah. Some people are with us today who are involved in or have been involved in different kinds of litigation, and my heart goes out to them, being a father who's lost a son. And these are all people who've lost children in different kinds of interactions with chatbots and other kinds of AI technology. And I just want to recognize Kristen Bride from Oregon, who lost her son Carson. He was 16 in 2020. It was the same year we lost our son Tommy. Juliana Arnold, who lost her 17-year-old daughter Coco to fentanyl poisoning after she purchased a counterfeit pill online. Megan Garcia from Florida, who lost her 14-year-old son Sewell, who took his life in February after months of abusive interactions with a character AI chatbot. And Jane Doe from Texas, whose son JF suffered severe physical and mental health harm after multiple chatbots instructed and encouraged him to engage in self-harm and self-violence. And so all of which is to say, in my mind, there are profound problems here that we really do need to deal with. And the last thing I would want to do is to try to nullify states that have already addressed the problem in response to constituents dealing with a nightmare like that without replacing it with something. And I'm not averse to the idea that there might be a national law that works, but certainly imposing a legislative vacuum on the country would be a really dangerous way to go. Thank you, Mr. Chairman. I yield back to you.
You're most welcome. And with that, we go to the gentlelady from Florida for 5 minutes.
Thank you, Mr. Chairman. Mr. Frazier, I'd like to return to you. I appreciate so much your discussion of the Commerce Clause, and I think you made some important distinctions for us already in your testimony when you talked about the need for the federal government to intervene and think about preemption when we're talking about a subject that affects the economic or political stability of the United States. And you drew a distinction between pigsties and artificial intelligence. Would you elaborate for us, please, about why you believe the things that we're discussing here today do go to the heart of the economic and political stability of the United States and should be distinct from those areas where the laboratories of democracy concept actually works?
Thank you for the question, Representative Lee. I think it's profoundly important to get back to that Brandeis quote about laboratories of democracy. There's a forgotten portion of that quote, which is without risk to the nation. You can run an experiment without risk to the nation. Many of these experiments that we're seeing proposed and enacted in California do pose a risk to the nation because they try to impede AI innovation itself. When we see individual states reach into the AI development process, they're not just tinkering with a modular process. There's not an AI-specific training run for California that OpenAI does. Anthropic doesn't train its models 50 times over for each state. So while there may be a lane for state regulation, and I believe there's a lane for state regulation with respect to AI use, we have to follow up and ask the question of what does a real experiment look like? And that experiment can't be one that exceeds the borders of that state. And yet California's bills time and time again would result in labs having to change their practices the nation over. And I've lived in California, I've lived in Florida, I've lived in Texas, I've lived in Oregon, I've lived in Massachusetts and in DC. And I can tell you in each of those places, they don't want Californians dictating the terms of their AI.
And I also need to follow up on this question. You said something interesting when you were talking about current copyright law, how it operates in really ensuring that we are still honoring the concepts of content creators and intellectual property. You suggested an economic analysis of what's happening with the use of this content and training models. Would you elaborate for us a bit more on how that would look and how we can get to the bottom of how to properly compensate those content creators?
Happily, thank you for the question. If you look at current settlements, for example, in the Bart's v. Anthropic decision, and you begin to analyze who may those funds actually go toward, a large number of that fee is going to go to publishers. It's not going to go to the actual authors themselves. So if we are trying to incentivize the creation of new art and new discoveries and new scientific discoveries, copyright may not be the vehicle we need. It's not serving the same purpose it did in 1789, back when it was just limited to 14 years with the possibility of a 14-year renewal. It is now 70 years plus the life of the author. That is an incredibly long time, especially when you consider that the founders really hated monopolies. So the fact that we've ended up in a world in which a handful of publishers may be able to dictate the quality of our AI, I think is antithetical to the original purpose of the IP clause.
Thank you. And Mr. Thayer, one of the things that you touched on was the idea that Congress could explore giving NIST or CASI more authority to develop standards for AI frontier models. Would you share more on your perspective of how we might do that? Should we designate a single federal entity to try to develop those standards? Share with us a little more on your thoughts there, please.
Yeah, absolutely. Thank you for the question, Congresswoman. Let's be clear that the reason that NIST needs to play a role here in this new CASI body is because they have the ability to address exactly what the problem is here, which is that many states are attempting to impose a very technocratic type of design on artificial intelligence models and systems preemptively in an almost European-style way. And that's a huge problem. I'll just again quote from Governor Jared Polis, who said, "Government regulation that is applied at the state level in a patchwork across the country can have the effect to tamper innovation and deter competition in an open market." But it's not just that. These states lack the technical capability to do some of this in certain circumstances, and they lack the information needed to do it properly. We have set up this body, I should remind the committee, set up under President Biden and retained by President Trump in a bipartisan move, and just renamed to focus more on standards and innovation. That's a good plan. Once again, we have a bipartisan agreement here. We've got a new technical body, and it can handle it in conjunction with other existing policies, both federal and state.
Thank you, Mr. Chairman. I yield back.
Thank you. We now go to the gentlelady from California, Ms. Lofgren.
Thank you, Mr. Chairman. And before I make remarks or questions, I'd like to ask unanimous consent to put into the record a letter from the California Privacy Protection Agency.
Without objection, so ordered.
Thank you. You know, the title of this hearing, Californication, I take a little bit of exception to. You know, I get it. People bring up California because we set the pace. But it's worth noting that I think my colleague from California, Mr. Correa, mentioned California is the fourth largest economy in the world, with over 4.1 past Japan last year and trailed only Germany, China, and the United States as a whole. It's number one. California's the number one state for manufacturing. It's home to the most Fortune 500 companies of any state. More than 40 are in Silicon Valley, my home. It also has the highest agricultural output of any state. It's home to the nation's, 5 of the nation's top 10 public universities, UCLA, UC Berkeley, UC San Diego, UC Davis, and UC Irvine. It accounts for over 12% of all university R&D expenditures in the United States, with the University of California system alone spending more than $12.1 billion, and it receives more NIH funding than any other university system in the United States. Now, these aren't just vanity stats, they're the foundation of the modern innovation economy that California has built. World-class universities, labs, investors, entrepreneurs, workers who turn ideas into jobs, into growth. California has been and remains the leader in technology, and the engine that built our economy now powers our AI leadership. California leads the world with 32 of the top 50 AI companies based here. So I do think, although it's always fun to criticize the most successful state, we must be doing something right to have achieved all of this. Now, this is a hearing on AI, and some of the comments made by the witnesses I agree with. Mr. Bray, you mentioned that upgrading existing domain-specific laws is more pragmatic than attempting sweeping new regulations. I very much agree with that. But I think that's also going to need room for regulations that are specific or laws that are specific to each state. I mean, there are things that are the proper purview of states, and there are things that are the proper purview of the federal government. And certainly I was a critic of Mr. Wiener's bill from the last session in that it overreached in the national security effort. I also agree, Mr. Thierer, that the EU approach is incorrect. I mean, to try and micromanage the workings of the AI system is doomed to failure, it seems to me. However, the recommendations that we simply preempt when we have nothing put together now is problematic. And I've just got to say, Mr. Chairman, and you are also a member of the Science Committee along with me, we had a pretty effective bipartisan task force on AI in the last Congress, chaired by Mr. Obernolte from California, as well as Ted Lieu from California. And they took the first step. I mean, they didn't finish the job, but they haven't even been reconstituted in this Congress. We do heavily rely on NIST, an agency that is widely respected in the Congress and in the technology world, but we've got to look at what's happened to NIST. They've been eviscerated by the DOGE people, and I fail to see how they're going to be able to perform the tasks that we're hoping that they can perform, given what has happened to them. So I would just like to say that we ought to be working on a bipartisan basis again. The Science Committee staff the task force. I would urge the Speaker and whatever influence the Chairman can have to reestablish that AI task force as a super subcommittee of the Science Committee so that we can get more work done and get to where we need to be to have the guardrails and the standards that are appropriate at a national level, while also recognizing there are things that are of value in the state level. As the note from OpenIA just mentioned, Buffy Wick's online age verification is something they support. So there are things that the states can do, there's things that the federal government can do, but we're not going to do anything unless we can get our act together and reinstitute that task force and get some more work done. So with that, Mr. Chairman, I yield back.
I thank the gentlelady, and I might note that both sides of the title reflect California as the home of the innovation that's driving it. I might also take an opportunity to completely agree with your comments related to the need for us to act, that a preempting without a solution, without some of the work that is being currently worked on both here in the House and Senate would not be well received. So I think we have the groundwork for a lot of the kinds of work that you and I have done together. And I look forward to very much this hearing being the beginning of us launching bipartisan legislation, because we do need to act in some cases, and you have always been a good partner in that acting. And with that, we continue on with deference to my great state, the Commonwealth of Virginia. We'll continue with the California effort and go to Mr. Kiley for 5 minutes.
Thank you, Mr. Chair, and I wholeheartedly agree with my colleague from California that our state continues to be the center of breathtaking innovation worldwide. However, the competency of our state government is another matter entirely, not to impugn the competence of any of my former colleagues in the Sacramento legislature, but this is a body that struggles with things like building roads, delivering electricity, managing forests, building dams, and getting water to come out of hoses. So the notion that this is the right body to regulate the most powerful technology in human history, whose workings are actually largely beyond the understanding even of the technology's creators, is a fairly fantastical notion. Not only that, but we are also faced with a technology that continues to accelerate in capability in an exponential way, in a way that is unlike anything we've seen before. Just to take one very specific example, you have leading models have recently gotten the gold medal in the International Math Olympiad, something that most experts thought was still going to be years away. And so I do think the risk that California is going to drive AI policy for the entire country is a very real one. And I think that